As already we have finished those leading cases that we have discussed and already uploaded those lectures as insurance leading cases 1 and 2, and also insurance leading cases 3 relating to life insurance, fire insurance, and marine insurance, and in the last one that we have already promised to discuss about those important leading cases relating to motor vehicle act of 1988 and the amendments made in that connection to in 2019, and in consequence to those we want to discuss certain important leading cases decided by the Supreme Court, which are considered as landmark judgments in relation to Motor Vehicle Act of 1988 and the very amendments made in regards to the provisions of the Act in the year 2019, and in that connection, we'd like to discuss one important leading case decided recently in 2022 by the Supreme Court, and that is the case of Sajan Singh Yadav and others, which was decided previously by the Patna High Court. So, in an appeal, the Supreme Court held that compensation can exceed the claim. As Supreme Court has reiterated that the Motor Accident Claim Tribunal can award more than the amount claimed by the claimant if the court determines that the claimant is entitled to a higher amount. So the court has the duty to calculate fair compensation. So also the Supreme Court in the very judgment expressed that compensation can be released in parts. So the Motor Accident Claim Tribunal has the discretion to release compensation in parts or all at once. The tribunal must provide its own reasoning for the decision. So also Supreme Court in this very judgment expressed that the State Legal Services Authority guidelines are not binding. The Supreme Court has observed that the guidelines issued by the State Legal Services Authority for disability compensation are not binding in cases where proof of earning is available. And so also Supreme Court has said that delay should be condoned if there is a sufficient cause for the delay, as it is considered a sufficient cause, regardless of the length of the delay. And finally, Supreme Court expressed in this particular decision in 2022 that the very standard of proof in motor accident claim tribunal cases is based on the preponderance of probability is not proved beyond a reasonable doubt. And in that regard, also we want to discuss some other important leading case that we have selected in relation to the Motor Vehicle Act of 1988, and in that connection we want to discuss the second important landmark judgment made by the Supreme Court in the leading case, Rajasthan State Road Transport Corporation versus Kailasnath Kothari and others in 1997. So, in that regards, what exactly will would like to go to the very fact of this case, as in this said case. The plea was taken by the Rajasthan State Road Transport Corporation before the High Court, that as it was only a hirer and not the owner of the bus, it was only hirer and not the owner of the bus, it could not be fastened with any liability for payment of compensation. But the said stand was not accepted. It was contended before this court that the corporation, not being the owner of the bus, was not liable to pay compensation arising out of the accident because the driver who was driving the bus at the relevant time was not in the employment of the owner of the bus and not the corporation, and hence it could not be referred and could not be held vicariously liable for the rash and negligent act of the driver. But the court referred to the definition as provided in section 2 subsection 3, which defines contract carriage, and section 2 subsection 19, which defines the owner, and section 2 subsection 29, which defines state carriage, and section 42 that dealt with the necessity of permits. Be it stated, these provisions reproduced by the court pertain to Motor Vehicles Act 1939. The owner under the 1939 Act was defined as follows: as provided under section 2 subsection 19 of the 1939 Act, owner means where the person in possession of the motor vehicle is a minor, and in relation to a motor vehicle which is the subject of a hire purchase agreement, the person in possession of the vehicle under that agreement. So the court referred to the conditions of the agreement from 4 to 7 and 15 of the agreement, and in that context held that the admitted facts unmistakably show that the vehicle in question was in possession and under the actual control of the Rajasthan State Road Transport Corporation, for the purpose of running on the specified route and was being used for carrying on hire passengers by the Rajasthan State Road Transport Corporation. So the driver was to carry out instructions, orders, and directions of the conductor and the other officers of the Rajasthan State Road Transport Corporation for operation of the bus on the routes specified by the Rajasthan State Road Transport Corporation. And in regards to that also you would like to discuss another important leading case, and that is the landmark judgment number 3 in regards to TB Jose versus Jacobian, and it was decided in the 2011 by the Supreme Court. So here exactly the court referred to the authority in this case wherein it has been held thus by the Supreme Court. There can be transfer of title by payment of consideration and delivery of the car. The evidence on record shows that ownership of the car had been transferred. However, the appellant still continued to remain liable to third parties as his name continued in the records of the regional transport officer as the owner. Thereafter, the court held thus the decision in this case was rendered under the Motor Vehicle Act of 1939. But having regard to the provisions of Section 2, subsection 30 and Section 50 of the Act, as noted above, the ratio of the decision shall apply with equal force to the facts of the case arising under the Motor Vehicle Act of 1988. On the basis of these decisions, the inescapable conclusion is that Jitendra Gupta, whose name continued in the records of the registering authority as the owner of the truck, was equally liable for payment of the compensation amount. Further, since an insurance policy in respect of the truck was taken out in his name was indemnified, and the claim will be shifted to the insurer. And in this case, the very insurer was Oriental Insurance Company Limited. And so this is one of the most important leading case decided by the Supreme Court. And now we'll go to the fourth landmark judgment decided by the Supreme Court, and that is National Insurance Company Limited versus Deepa Devi and others, and it was decided in 2008. So, where exactly it was held that in this leading case, the question arose whether the event a car is requisite for the purpose of deploying the same in the election duty would be liable for payment of compensation to the victim of the accident in terms of the provisions of the Motor Vehicle Act of 1988. The court referred to the definition of owner as provided in the previous Motor Vehicle Act of 1939 and the definition of owner under Section 2, subsection 30 as provided under the Amendment Act of 1988. In that context, the court observed that the legislature, either under the 1939 Act or under the 1998 Act, had visualized a situation of this nature. The court took note of the fact that the respondent number 3 and 4 continued to be the registered owners of the vehicle despite the fact that the same was requisitioned by the district collector in exercise of the power conferred upon him under the Representation of People's Act of 1951, and the owner of the vehicles cannot refuse to abide by the order of requisition of the vehicles by the district collector. So, proceeding further, the court ruled that while the vehicle remains under requisition, the owner does not exercise any control thereover. The driver may still be the employee of the owner of the vehicle, but he has to drive it as per the direction of the officer and except for legal ownership for all intent and forfeit the registered owner of the vehicle loses entire control thereover. So he has no say as to whether the vehicle should be driven at a given point of time or not. He cannot ask the driver not to drive a vehicle on a bad road. He or the driver could not possibly say that the vehicle would not be driven in the night. The purpose of requisition is to use the vehicle for the period the vehicle remains under the control of the state or its officers. The owner is entitled to payment of compensation, therefore, in terms of the act, but he cannot exercise any control thereupon. In a situation of this nature, the court must proceed on the presumption that Parliament, while enacting the Motor Vehicle Act of 1988, did not envisage such a situation. If a given situation, the statutory definitions contained in the Motor Vehicle Act of 1988 cannot be given effect to in letter and spirit, the same should be understood from the common sense point of view as it was declared by the Supreme Court in this very important leading case. And that was in 2008 in between National Insurance Company Limited versus Deepa Devi and others. And now we'll discuss the fifth most important leading case in relation to Motor Vehicle Act is Punya Kaladevi versus State of Assam, and another in 2014 the Supreme Court expressed, and as regarding to that, in this particular important leading case. A three-judge bench was dealing with the issue when an offending vehicle is that under the requisition of the state government under the Assam Requisition and Control of Vehicles Act 1968. The registered owner would be liable or the state government that has requisitioned the vehicle. The court referred to the very definition of the term owner as provided under the 1939 Motor Vehicle Act as well as the definition provided under the 1988 Motor Vehicle Act. As was necessary in the said case, the court referred to the relevant provisions pertaining to release from the requisition under the Assam Requisition and Control of Vehicles Act 1968. After analyzing the provisions, the three judges then set aside the award passed by the Assam Guwahati High Court, which had held that the owner was liable solely on the basis of the definition of the word owner as contained under Section 2, subsection 30 of the Motor Vehicle Act of 1988, and the very dictum laid down by the Honorable Supreme Court in this said case is as follows. The High Court failed to appreciate that at the relevant time the offending vehicle was under the requisition of Respondent number 1, State of Assam, under the provisions of the Assam Requisition and Control of Vehicles Act 1968. Therefore, respondent number 1 was squarely covered under the definition of owner as contained in Section 2, subsection 30 of the Motor Vehicle Act of 1988, and also the High Court failed to appreciate the underlying intention in including in the definition of owner a person in possession of a vehicle either under an agreement of lease or agreement of hypothecation or under a hire purchase agreement to the effect that a person in control and possession of the vehicle should be construed as the owner and not alone the registered owner. The High Court further failed to appreciate the legislative intention that the registered owner of the vehicle should not be held liable if the vehicle was not in his possession and control. So, this is one of the outstanding landmark judgment delivered by the Supreme Court in this particular important leading case. And now we'll go to another important leading case, and that is relating to Punyakala Devi versus State of Assam. That already we have discussed. Now we'll go to Union of India versus the Khasawa Philipsin Jala in 2011, and as it was decided by the Gujarat High Court. So, in that connection, would like to discuss the very decision delivered by the Gujarat High Court. So, in that connection, we found that in regard to that important leading case, and as it was decided by the Gujarat High Court in 2011, where exactly the matter was regarding interim compensation. So it was held by the Gujarat High Court awarding interim compensation, service benefits including the pension of family received by the complainant because of death of the husband cannot be adjusted under the section. They have nothing to do with accident claim under the Motor Vehicle Act before the claim tribunal, as it was held by the Gujarat High Court. And now we'll go to another important leading case, and that is in relation to Gujarat State Road Transport Corporation versus Ramabhai Pravatbhai 1987, where the Supreme Court exactly dealt with the hit and run cases. So, as provided under Section 109A to Section 109C of the Motor Vehicle Act of 1939, and as it was amended in 1988 as provided under Section 161 and Section 163 of the Motor Vehicle Act of 1988, which contained the special provision relating to scheme for granting relief to victims or the legal representative of victims of hit and run cases, motor vehicle accident cases, another novel effort on the part of the government to remedy the situation created by the modern society, which has been responsible for introducing so many fast moving vehicles on road, as it was decided by the Supreme Court. And in that regard, we have discussed the Gujarat State Road Transport Corporation versus Ramabhai Pravatbhai, and it was decided in 1987 by the Supreme Court. And now we'll go to another landmark judgment, and that is relating to Shivaji Dadu Patil versus Bhasala Uttam More, and it was a landmark case of 1991 and also in 1996 decided by the Supreme Court, and it was regarding waiver of rights and also in relation to meaning of accident. So in the 1991 case, it was regarding waiver of rights. The insurance company pleaded that it had the right to get rid of the policy because of non-disclosure of previous convictions of the assured and his sufferer. The insured contended that the company had paid for stay of proceeding because of the arbitration clause, and therefore the insurer had asserted and affirmed the validity of the policy by asking for stay of proceeding by reason of the arbitration clause. That amounted to a waiver of the right to insist upon non-disclosure. The court expressed that invocation of the arbitration clause did not amount to any waiver of rights, and so also the very meaning of accident in terms of that accident arising out of the use of a motor vehicle is to be contrasted with the expression caused by the casual relationship between the use of a motor vehicle and accident, which resulted in death or disablement, need be direct and proximate. As already we have discussed that maxim, causa proxima. This explanation was offered by the Supreme Court in this important leading case and held that the explosion and fire resulting in the injuries which led to the death of the respondent's son was due to an accident arising out of the use of the motor vehicle, the petrol tanker, and also the Supreme Court held that section 92A was in the nature of a beneficial legislation enacted with a view to conferring the benefit of expeditious payment of a limited amount by way of compensation to the victims of an accident arising out of the use of a motor vehicle on the basis of no fault, liability in the matter of interpretation of a beneficial legislation, the approved of the courts is to adopt a construction which advances the beneficent purpose underlining the enactment in preference to a construction which tends to defeat the very purpose. So, in this very important leading case that we have discussed, which are relevant in the context of the very definition of waiver of rights and accidents as it was decided by the Supreme Court. And now we'll go to another important leading case, and that is relating to Union of India versus United India Insurance Company Limited, decided in 1997 by the Supreme Court. So, in that regard, we would like to discuss when the very driver with fake or no license in that case, where prior to the hiring of the driver, the owner satisfied himself that the driver had a license and was driving competently. So it was held that there was no breach of duty under section 149, subsection 2, clause 1 and subclause 11, and the insurer was not discharged from liability even if ultimately it was discovered that the license was fake. The insurer would liable unless he could prove that the owner was aware of the fake character of the license and even so retained him as a driver. The insurer was liable to the injured third party, though he might be in position to seek indemnity from the owner. And another important leading case, that would be the last important leading case we would like to discuss, and that is Ashok Gangadhar Martha versus Oriental Insurance Company Limited, decided in 1999 by the Supreme Court. So, exactly, here the very issue was regarding effective driving license and license for light motor vehicles as provided under Section 147 of the Motor Vehicle Act of 1988. So a license was issued in Form 6 for the light motor vehicle remains a valid license whether light motor vehicle is for goods or a transport vehicle. An effective driving license means a valid license both as regards the period and type of vehicle. So the Supreme Court expressed that the word effective in the expression effective driving license as provided in Section 3 of Motor Vehicle Act of 1988 means a valid license both as regards the period and type of vehicle. For a vehicle to be a transport vehicle, it must be in good carriage, which in turn means any motor vehicle contracted or adopted, used for the carriage of goods. The Motor Vehicle Act contains the definition of heavy goods vehicle and medium goods vehicle, but there is no definition of light goods vehicle. Instead, the definition of OP light motor vehicle, if one applies the very definition of light motor vehicle as given in under section 2, subsection 21 to mean a transport vehicle, which in turn means a goods carriage, then one would have known where the definition of a light motor vehicle without it being a good carriage. So, Section 2 of the Motor Vehicle Act begins with the words in this act, unless the context otherwise requires. One has therefore to give a meaningful interpretation to the expression light motor vehicle as given in section 2 subsection 21 rule 2 of the Central Motor Vehicle Rules enacted in 1989, which defines non-transport vehicle to mean a motor vehicle which is not a transport vehicle. The definition would therefore take out of the definition of transport vehicle as given in clause 21 in regards to light motor vehicles which are not goods carriage. So, in this very lecture, almost we have discussed all the landmark judgments in relating to the cases falling under the Motor Vehicle Act of 1939 and also subsequently when it was completely replaced and repealed and enacted as Motor Vehicle Act of 1988 in regards to certain important definitions and ambiguities and confusions relating to owner and in regards to driving license and also in regards to requisition of a motor vehicle by the state. So almost we have covered all aspects of Motor Vehicle Act and those relevant questions that arose before the apex court or the Honorable Supreme Court, which were decided. So, in that context, we have selected only 10 important leading cases and almost we have discussed all the 10 relevant important leading cases which are dealing into Motor Vehicle Act. And in that context also we have discussed our first important leading case, and that was the most latest landmark judgment delivered in 2022 by the Supreme Court in the case of Sajan Singh Yadav and others. So, in our next upcoming lecture, we would like to discuss all those important leading cases relating to motor accident claim tribunal cases.